against the spirit of the Constitution. It's against the Constitution. It's against Article 19, freedom of speech and expression.
This law is one that has absolutely no place in a democracy.
We respect the court, we respect the independence of the court, but there are things which is called Lakshman Rekha. All the organs of the state must respect each other.
The larger issue is that any plea of sedition has to be re-examined, keeping the country's safety and security in mind, and also the civil liberty of citizens.
News Epicenter with me, Maria Shakir. In a landmark move by the Supreme Court, the sedition law has been temporarily suspended. The Apex Court has asked the centre and states to refrain from registering any more FIRs invoking Section 124A till re-examination of the law is complete. Proceedings in all pending cases have been stayed as well. Those jailed for sedition can approach courts for bail. The next hearing is on May 17. The Chief Justice of India has said that the challenge is to balance the security of the state and the civil liberties of citizens. Referring to Attorney General K.K. Venugopal's submission of glaring instances of abuse of the law, the recent case being the action against the Ranas over the Hanuman Chalisa row in Maharashtra. Solicitor General Tushar Mehta argued that Section 124A represented a cognizable offence. He even argued that a senior law officer senior officer at the level of Superintendent of Police could scrutinize the facts of individual cases prior to registration of FIRs in a bid to prevent any abuse, adding that there could not be a blanket ban or freeze in the prosecution of pending cases as they involve charges of terrorism and money laundering. Senior advocate Kapil Sibbal, appearing for the petitioners, objected to the centre's proposal, claiming there are currently 13,000 people in various Indian jails on charges of sedition. This comes 2 days after Prime Minister Narendra Modi instructed the central government to reassess the necessity of the colonial law. The government's affidavit before the top court states that while such laws are necessary to tackle serious offences, legal codes that reek of colonial mindsets have no place in today's India. The sedition law was introduced by the British in 1870, penalising speech, action and writing deemed insightful and targeting the sovereignty and integrity of the state, with punishment of 3 years to a life term. It was actively mobilized against freedom fighters during the independence movement. And in the modern era, it has become a political tool. Time and again, it has been invoked against political opponents by different governments with an aim to send a message. From 2014 to 2020, 319 sedition cases have been registered with just 8 convictions. This is a conviction rate of just 2%. But Law Minister Kiran Rijiju echoed the sentiment that there must be a Lakshman Rekha, which is respected by all. The argument in favour of the law is that with instigators like Pakistan and terror threats going online, it is necessary for national security, and the judiciary should be the real check against abuse. The question at the centre of this raging debate is, can the law be applied in a balanced manner? Can it exist with real safeguards, or are multiple cases of its highly politicized application grounds to end this colonial law? Joining me now is top 2 lawyers of India to share their views and perspectives. Satish Manishinde and Rizwan Merchant are joining me live. Rizwan Merchant, relief for your clients, the Ranas, would you say, had the government not shown its intent in the affidavit that it will reconsider and re-examine the decision to put the law on hold, the decision to put the law on hold would not have come?
Well, Madam, let me tell you one thing. As far as the Ranas are concerned, the misuse of Section 124A was writ large on the conduct of the state government in the instant case for the simple reason, at the time when the FIR was registered by Khar police station against the Ranas, the only charge that was applicable was 153A and certain provisions of non-compliance of the provisions of the Bombay Police Act. It was only when the remand application was produced before the court seeking remand that the court was informed that section 124A has been invoked on the basis of certain alleged statements which have been made by the Ranas during the course of certain press interviews. Now, those particular statements were not even a part of the remand application. So, without even having any material in their hands, a case of 124A was slapped on the Ranas, which categorically shows that 124A was nothing but a mechanism and a tool to misuse so that they are able to ensure that custody is granted to them under the pretext that this is a case of sedition. Now, I'm extremely happy that the Honorable Supreme Court has taken up this particular issue, which has been pending since July 2021 and now in May 2022, along with the efforts which have been put in by the Solicitor General, as well as the Honorable Prime Minister, who has made it very clear that he is cognizant of the fact that these old-age colonial laws need to be scrapped. In 2014-15, we've seen that the government has scrapped nearly about 1,500 laws, nearly about 25,000 compliances have been scrapped. So this is something which was expected. The only thing is it's a bit too late, but it's better late than never.
Okay.
Now, the matter has been listed in July 2022. What is to be seen is what is the effort which the government is going to be putting in re-examination. We do appreciate, and we are with the government on this issue, that security and integrity of the state is of prime importance. We need to ensure and secure the security and the integrity of the state.
Okay.
But it should not be something which should be subjected to misuse. The element of misuse generated here, that if you express any disaffection or disapprobation towards the government, they slap 124A. That disaffection and disapprobation all by itself cannot amount to sedition for the simple reason it is my fundamental right to express disaffection towards anybody. It is my fundamental right to express disapprobation towards anybody.
Yes.
You cannot stop me from doing that.
Yes.
But if I exceed and if I cross the line, as a result of which there is an incitement to violence, there is an incitement to violence because of my expression of disaffection, expression of disapprobation, then you can bring in sedition. Now, in the case of Ranas, even if you say that there was a particular statement that was made by them against the Chief Minister all by himself does not become the state government. And there was no incitement of violence. So they may have expressed a disaffection towards the Chief Minister. They did not express the disaffection towards the state government.
Yes.
Therefore, there was no incitement of violence. It's a classic case of misapplication of 124 capital.
Okay. Mr. Manishende, the government is saying that the Supreme Court has not stayed the provision of sedition as wrongly claimed by certain sections, but has merely expressed its expectations that no person will file FIR for sedition. And they are talking about a specific para. Just put this in context. What happens in the next few days? Can an FIR be registered, and can it be done by the local cops?
The Supreme Court cannot grant an order directing the state government or the central government to not register an offence under section 124A as long as it stays in the law books. The Supreme Court has not stayed any offence being registered. All that the Supreme Court has said is that in case certain persons are charged for an offence under section 124A, those people can approach the Honorable Court in whichever jurisdiction they are, and the Honorable Court will consider their pleas, keeping in mind the facts of the case and the provisions that are applied. There could be cases like it happened in the 1984 at the Golden Temple, where a large number of people collected and waged war against the state. So such people, if they are in possession of firearms or dangerous weapons or explosives, they could be charged under other offences along with section 124A, because such offences can be easily made out. And what the state government has, central government has told the Honorable Supreme Court is that though it opposed interference with the law, since it was already considered by a 7-judge bench And the bench that was hearing the matter before the Supreme Court was a 3-judge bench. The central government was bold enough to say that we will not accede to any request or any prayer of the petitioners to relook this issue because a 7-judge bench of the Honorable Supreme Court in Kedarnath's case has already held in the last 60 years that it has been constitutionally framed and it is legal. So the Supreme Court with a 3-judge bench could not have interfered with Kedarnath's judgment. Even today, the Chief Justice's Honorable Court, consisting of 3 judges, could not have interfered with that judgment. In case the Supreme Court wants to reconsider this issue, it has to be referred to a larger bench than 7 judges. But looking at the nature of the petitions and the archaic law that was being canvassed before the Honorable Supreme Court, and since the Honorable Prime Minister, right from the time he has taken charge, has always said that we will relook into all the legal provisions which are made by the Parliament and scrap laws which are redundant. 1,500 laws have been made redundant. So therefore, I feel that though the central government came into the picture and said that we oppose any interference with Section 124A by the Supreme Court, since it is constitutionally valid, looking at the nature of the Prime Minister's view on archaic laws and archaic provisions, the Honorable Prime Minister gave instructions probably to the Solicitor General to make a statement and file an affidavit, in the nature of which it has been filed, that it will relook into it. But what the Supreme Court has done by this order is by one blanket order, stayed all prosecutions, stayed all trials, which according to me is too far-fetching.
What happens to cases like urban Naxal, I mean Bhima Koregaon case or Sharjeel Imam's case, etc., Mr. Manshinde, where other offences are also charged over and above the sedition and are permitted basically to continue by the Supreme Court? Is that the correct assessment?
Well, as long as new FIRs are registered under Section 124A only, then those accused can approach the court for reliefs that are sought. But if there are other offences registered, as in the Bhima Koregaon case, and remember one thing, that in Bhima Koregaon case, all the accused have gone to the Honorable Supreme Court several times, and the Supreme Court has refused reliefs. So there is no question of releasing such people because offences have been made out. There are other offences alleged against them. Supreme Court has already considered their bail applications. And if anyone were to apply for bail in the Bhima Koregaon case, I am sure that the Supreme Court may not interfere into these offences. But if there are new cases registered, like the Hanuman Chalisa case, the Supreme Court has itself mentioned about it, though the matter was not before the Supreme Court, that it was misused in that case. Obviously, it was misused. In such cases, a trial court or the High Court or the Supreme Court can grant bail.
Rizwan Merchant, when the government says that it will re-examine and reconsider, these are two very carefully chosen words. Is this an indication clearly that it's understanding the mood of the nation, where in multiple states, multiple cases, it has been a case of misuse and abuse of the law, and hence the government could be looking at safeguards, perhaps attempting to define this law rather than completely scrapping it?
What I feel the government would do, or in the nature of things that are prevalent in the country today, particularly in Kashmir and Northeast, is that they will redefine Section 124A, exempting matters like the Hanuman Chalisa case and other cases where only speeches are made and people are arraigned as accused. As long as they are not in respect of waging a war against the country, not in respect of overthrowing the government, not in respect of anti-national activities. And I'm sure the Prime Minister, who is being advised by a team of lawyers, would also reconsider whether mere speech or a mere speech of hatred against the nation should be considered as waging war against the country and invoking section 124A. Though this law was made in 1860, the definition as it stands today in the law books is very relevant for the purpose of taking action against anti-national elements.
Yes.
I don't think the law will be scrapped.
Okay.
The law will be redefined to exempt certain cases which are being taken up now, like the Maharashtra case.
Okay. Rizwan Merchant, what is your thought?
Maria, what I personally feel is, see, there are two important words under section 124A, the word disaffection and disapprobation. I personally feel that these two words will come in for a little bit of fine-tuning. They may eliminate the meanings which are generally attached to disaffection and disapprobation as falling under your fundamental right of freedom of speech. And they may bring in certain other acts of omission and commission, as Satish rightly suggested, that other acts of omission and commission where a person's act of omission and commission relates to a threat to security of the state and the integrity of the nation, or expression of hatred towards the nation. Hatred towards the nation, hatred towards the government. And that hatred should be such that it should lead to incitement of violence. That incitement of violence will have to remain. That incitement of violence will have to remain to accomplish the charge of sedition. But a little bit of redefinition and redefining of the word disaffection and disapprobation may be coming in. So that is what possibly the issue of re-examination and reconsideration may be looked into by the government.
Okay. Okay, and what happens to the trials? The court has certainly stayed trials where individual offence alleged in the FIR is only sedition.
Well, the court is the Honourable Supreme Court. The Honourable Supreme Court has maintained a very fine balance as far as this particular order is concerned. As far as new cases is concerned, the Supreme Court has said that the central government should issue necessary directions to the state government. That is because the Honourable Supreme Court expects that the state and the central government both should restrain from registering new FIRs. Okay. So it is the moment you expect something from the court, it is expected that you honor that particular expectation of the court. So I don't think if there is an expectation of the court, the central government or any state government would still venture into going in and registering in a particular FIR. Okay. And thereafter, if there is no FIR, no continuation of investigation, no coercive measures taken, no coercive measures would mean no arrest. Okay. But as far as other charges are concerned, for example, if 153A is applied in Rana's case along with 124A, 124A will be kept in abeyance and 153A will have to be proceeded with. Now the good thing is that the matter is now kept in July 22. If you had stretched this, what would have happened is, if the matter goes to trial and if the court frames charges as far as one charge is concerned, the other charge being kept in abeyance would mean the court will not be able to deliver judgment in that particular case until such time as that second charge is not added to or subjected to trial. Okay. So this would have caused a lot of complications for the trial courts to deal with cases where there are multiple charges apart from 124A, because a charge is required to be framed individually in respect of each charge. So after having framed charges for charges other than 124A, keeping one particular charge in abeyance, completing the trial, and then going de novo all over again for the trial would have caused a lot of loss of time, lot of judiciary time, loss of time, money, energy. So I think we should expect some outcome of the reconsideration and re-examination by July 22. Government has got a good 3 months' time, and I think they should be able to come forth with some particular solution.
All right. Satish Manishinde.
One thing I want to...
Yes, please go ahead, Mr. Manishinde. Yes.
Is this Act of Parliament of 1860 can be looked into only by the Parliament.
Yes, yes.
Unless it is placed before the Parliament in time. And I think the next session of the Parliament is only the monsoon session.
That's right.
And there's no chance of the Parliament meeting before July 22.
Okay.
And considering and sending it to the Rajya Sabha, where the law also has to be relooked and repassed, I don't think it's going to be within that short time. And such a law cannot be relooked
through ordinance
within a short period.
So what about the
We
ordinance
have to
rules?
think of the security of the nation.
Okay. Satish Manishande and Rizwan Merchant, really appreciate your time. Yes.
Satish,
Yes.
I would beg to differ with Satish for the simple reason, this is one particular government which has always meant business. If from 2014 to 2015, 1500 laws can be scrapped, I don't think this government would take that much of time to reconsider, re-examine 124A and come with a solution by July 20.
Okay, let's see whether
I'm sure
solution
they mean
is...
business and they will do it. I'm confident they will do it.
Security of the nation is concerned, it's topmost priority, and it can't be wished away in 2 months.
Absolutely.
All right. Thank you so much for joining us for that argument, Satish Manishande and Rizwan Merchant. Shifting focus now to our newsmaker, Mahua Moitra. She is a TMC MP and one of the petitioners. Ms. Moitra, appreciate your time. You have been one of the most vociferous critics of this law. In the past, several leaders have raised the concern as well, but you took the legal route. How do you see it today in terms of your own battle?
I was not the first petitioner on this. I am one of many. But this is a very important battle that could only be fought through the courts because the statute has been on the book since 1870. So many governments have come and gone in independent India. Nobody's removed this. This particular government, which in the last minute put in something saying that, this is the Prime Minister's had this epiphany and he thinks it shouldn't belong there. Well, he's been in power for 8 years and he hasn't done it before. So it's high time that this law was removed. We're thankful to the Supreme Court. What is important to understand is that the government is spreading this narrative that, by the way, we were going to reconsider it anyway, and the Prime Minister, and they've repeated his name ad infinitum. It has nothing to do with that. What the government came and said on affidavit day before yesterday was, can the Supreme Court please lay off? Can you please lay off and we will reconsider the law? Well, if the government wanted to do that, the government cannot say anything on behalf of Parliament. How can the government put on affidavit what Parliament will do? There is case law that says the government can't do that. And number one. Number two is that this morning at 10:30, the Solicitor General put in a written submission in which he said that the court can do nothing. We will reconsider it. And why don't you just have a DGP in every state that will decide when to apply the law or not? So if that had happened, it would have been terrible. My lawyer, Gopal Shankar Narayan, has put in a one-pager, then submitted a one-pager, which I've given you a copy of, which was given to all the judges, which said that, fine, let the government go in and reconsider in their wisdom. We welcome it. There's nothing wrong. But in the meantime, all the people who have been arrested, detained on this particular law have to be able to apply for bail and be released. Number one. The second thing is nobody new can be picked up on this act. This act has to be effectively stayed till such time a final decision is taken on this either by the government or by the courts. This law has to be effectively stayed. And if you see what the court has said, that's what the court has said. And they have informed the state chief secretaries, the state DGPs, all of them. The government also tried to hide behind something and say that, look, it's the state governments which do this. The central government don't do this. Police is on list number 2, but that's not really correct. If you see Minal Pandey, if you see Rajiv Sardesai, these were all FIRs which were filed by the Delhi police, who, as you know, report to the central government. So that again was a failure. So I'm very glad that the court has seen through.
Formation of law and scrapping of law is the domain of the Parliament of India. The government has shown that intent. The court could have not taken this call had it not been because of the government affidavit. Then in that case, would you not accept that the government perhaps has understood the mood of the nation, which is against this archaic law, and hence this affidavit of reconsideration?
Maria, this reminds me, if you see in privacy, if you see in Puttaswamy, if you see in marital rape, as you see in this, if you saw on the farm laws, this government does not accept anything unless it is forced into a corner. Okay, number one. So even with the farm laws, they stuck to it. When they realized there was no way out, they repealed it. So I am in Parliament. I have seen that with brute majority, the way they shove everything down our throats. They have absolute majority in the Lok Sabha, and now with 100 in the Rajya Sabha, they have actually majority in both houses. So Parliament in that way is a rubber stamp. Whatever the government wants to do, they can actually do. And there is no telling that they said they would reconsider. They did not say that they will repeal it or they will revoke it. So it is very possible they would come out with a moderated version of this act, where they would say, okay, we put in this restriction, that restriction, that restriction. You have to understand in 1962 with Kedarnath, on paper, there is already a restriction that mere criticism alone does not amount to sedition.
Yes.
And then by that logic, how can a comedian be picked up? How can Rajdeep be filed for sedition? How can Siddharth Varadarajan be charged under this act? So on paper, this exists. And if the government were to come back with an amended law, that would come under the definition of reconsider.
Okay.
So are you going to leave that to what I would say, because the government, frankly, for people like us, the trust deficit is so large, that with any other government, if they said they would reconsider it, we would take it to believe that they would scrap it. With this government, we don't know.
Okay.
Which is why we had to fight so aggressively in the Supreme Court. And I'm very glad what the Supreme Court has done in its wisdom is strike a balance. They've told the government, fine, you want to reconsider it, great, go back and do it. But till such time you do it, and till such time you take 1 year or 2 years to do it, the law cannot be applied.
Okay, ma'am,
which is a very happy medium.
We have seen repeatedly state after state governments, the central government, the BJP government, Congress government, and the Trinamool Congress government in the state of Bengal as well, has abused and misused this law. My question is, do you think the necessary safeguards, if that were to come in, while the sedition law remains, will ensure that the real purpose of sedition law will be served with the necessary safeguards?
Not at all, Maria. And, I would really advise you to go back and read the 1962 Kedarnath Singh judgment, 1962. I would advise you to go back, because this battle has already been fought in the Supreme Court in 1962. A 5-judge bench already laid out that you have to be subverting the government, and mere criticism doesn't amount to it. It has to be what in the US Supreme Court said in 1969, Brandenburg versus Ohio. They said that it's not clear and imminent danger. It has to pass the test of imminent lawless action. So basically, a person has to be doing something that is immediately inciting violence or immediately doing something under which sedition could come. But if you've seen, this is already on the books since 1962. But you see here, you are arrested for a joke that you may crack. How do you know what's going to come out of my mouth? And you arrest me for a joke that I may crack? You arrest me for an article that I may write. I am on my way to Hathras. I have not written the article. You arrest me for something. So how does that pass the test of either imminent lawless action or pass the test of mere criticism? It does not.
Okay.
So according to that, there is no question of any reasonable restriction. The law has got to go.
Okay. Is there a sense also in your government, which is the Bengal government, that if there are reasonable restrictions on this law, it will serve the purpose? Or are you of the opinion, and your party as well, that it should be scrapped completely?
This law should be scrapped completely. It's a black or white. This law deserves no place in a civilized democracy. It is a law dating back from 1870, where the British government put this in to basically be able to pick up Indians at women fancy. There is no place for an Indian government elected by Indians to be able to use this law against its own people. It's black and white. There are no reasonable restrictions. It's like saying I can beat up my wife if she annoys me, right? And then the court is left to decide as to what level one can annoy you in order for it to qualify as reason enough to beat up your wife. It's black and white. You cannot do it.
All right.
It's as simple as that.
Really appreciate your time. Thank you so much for joining us and sharing your thoughts. Joining me now is Ravi Shankar Prasad, BJP MP and former law minister. He joins me from Patna. Mr. Prasad, your political opponents and several others in the legal fraternity are of the opinion that it should be scrapped completely. My question is, why hold on to a colonial era law when the Britishers themselves struck it down 10 years ago? Is today's observation of the Apex Court perhaps a golden opportunity for the government to strike it down completely?
Well, it will not be proper or desirable on my part to make any comment on Supreme Court observations, because the matter is sub judice. But the larger thing I need to convey to you in very unmistakable terms, the Prime Minister himself has taken a very bold initiative, namely this being a colonial era law. In the 75th year of our independence, we will revisit it objectively, fairly, comprehensively.
Okay.
And that's a very good initiative.
Okay.
It needs to be appreciated. Instead of the court examining it, the government itself will examine it, which has been conveyed clearly by the Prime Minister himself. So he has taken the initiative. Therefore, I would suggest that let an objective consideration, consultation with all the stakeholders must be taken into account. And I think if in a Maharashtra government upon mere recital of Hanuman Chalisa, sedition provisions are being fastened, that is a glaring example of the need to revisit.
Yes. Since 2014, Mr. Prasad, close to 1,500 laws have been scrapped. I'm trying to understand what should be the road ahead then if the government has submitted that affidavit of reconsideration. Do you think it should be completely scrapped, or are you of the opinion that if there are necessary safeguards, particularly to do with defining what is sedition, then its abuse and misuse can be prevented?
First of all, remember one thing. When you say revisiting it, let us allow the course of revisitation to be undertaken. There will be consultation with stakeholders, consultation with eminent jurists, consultation with the need. Because, Maria, you being a very seasoned journalist, you need to understand that can you ignore there is no threat to the country's integrity and security and safety? Can you? Obviously, you cannot. There are elements openly hostile, including from across the border, including their cronies in India. Therefore, there has to be a case, compelling case if I can say that, for safety, security, in order to uphold the unity and integrity of India. Terrorism, secessionism, these are issues. Secondly, misuse is one thing. The larger issue is sedition has to be properly explained and defined,
Yes.
if at all retained,
Yes. Yes.
in a manner that there is a complete clarity before the law enforcement agencies as to how to go about it.
Okay.
These are only the possibilities which I told you as a student of law. But all those are matters of detail which need to be examined.
Okay.
But having said that, I would say that I would not make any comment on what Supreme Court said, but when we repealed close to 1400 plus laws, when I had the privilege to handle the law portfolio, the PM's view was very clear that we will revisit colonial era laws and would like to undo that legacy.
Okay. Mr. Prasad, while I understand that there are threats against the country and these threats are real, but why no government ever looked at it closely when activists, journalists, and even ordinary citizens were slapped with sedition cases?
Well, when the certain state governments have imposed the offence of sedition, maybe the police would not have prosecuted it. I am not supposed to be answerable for that. Here, I am trying to give my observations in the light of your query as to what prompted the government by the Prime Minister to consider revisiting this provision. If I would ask me, if I convey to you very frankly, I would say three factors basically. Number one, being the 75th year of India's independence, in this Amrit Mahotsav, the challenge to sedition gives an opportunity to revisit again the colonial laws. Number two, that India is taking its own decision as far as these laws are concerned. Second, what is its utility, its extent, when India has matured into a proper, stable democracy? But there are threats, as I said earlier. The third issue is equally important, which you told me.
Yes.
In the close to 75 years, many of my friends of the opposition who are openly challenging it, speaking about it, did their government undertake any exercise? For close to 55 years plus when Congress was the power on its own, and close to another, say 65 years when it was in power in combination with opposition parties, they did not. Therefore, and here contrast this with the Prime Minister taking a stand. When the challenge is set, let my government will undertake a proper exercise.
Okay.
So that should also be taken to be, I would say, a very open reappraisal of India's legal issues which are demanding an intervention objectively.
Okay. Mr. Prasad, my last question to you. So far, as far as the conviction rate in these cases are concerned, it's very, very low. So has the government also realized that this is a law which perhaps has no use in the present time? And if it is about unlawful activities, terror activities, then you already have a very strong UAPA.
Well, those are questions of detail, Maria. Many people are having problem even with UAPA. Huh? They want that law also to be scrapped. But since you are invoking my background as a lawyer and lawmaker both,
yes,
that is a loaded question you are asking. Ki conviction must justify the enactment. Enactment is different by the parliament.
yes,
Conviction is to be followed by a proper prosecution.
yes,
Whether the police undertook a good investigation, whether the prosecution argued the case well, whether all the evidence was produced in a particular case, those are separate issues. But let me very gently remind you, I am aware of your legal background too. Abuse are always there, no?
yes.
Should you scrap the section 302 of the Penal Code also, saying that the conviction under murder charge are not that extraordinary, or for dacoity, or for 420, or 379 for theft? Or income tax law should be scrapped because there is a lot of abuse? Therefore, we have to apply a different objective standard. Sedition being a colonial era legacy, how far it is relevant, in what form, to what extent, when India is today being a stable democracy governed by rule of law in the 75th year of its independence. That's the larger consideration which you must keep in mind.
All right, Ravi Shankar Prasad, I appreciate your time. Thank you so much for joining us, former Law Minister and BJP MP there. Shifting focus now to our last newsmaker on this topic, Manish Tiwari, Congress MP, joining me live. Mr. Tiwari, I appreciate your time. You're a lawyer as well, and this is a question to you, for you to wear that legal hat. Sedition law has been challenged many times in the court, and still it continues to be alive. In fact, while the British have made it non-cognizable offence, yet in the CRPC 1974, India made it a cognizable offence so that the police can arrest without a warrant. So how do you see the developments of the day?
And I think, Maria, you got the sequence of events wrong. When the British put sedition onto the statute book in 1832, it was a non-cognizable offence. But when the Indian Penal Code was instituted by the British, they actually made it a cognizable offence in case of India and also punishable with life. So therefore, it's just that this unfortunate prince among the political sections of the Indian Penal Code continued to remain on the statute. But it is not that it became a cognizable offence in 1973 when the Criminal Procedure Code was amended. It was a cognizable offence even before that.
Mr. Tiwari, the government today is saying that the judgment today extensively quotes from the affidavit of the central government. We can see that as well, where unequivocal views of the Prime Minister against colonial laws are being quoted. It is the government of India's views which form the very basis of the Supreme Court's order. What will you be saying on that?
Well, that's very rich for the simple reason that 3 days earlier, you take an unambiguous position that we are going to not repeal sedition, and sedition will stay on the statute books. 2 days later, you do a somersault and then try and pat yourself on the back. You know, this is like first raising a ghost and then slaying it and calling yourself Superman.
Okay, now tell me, sir, but the Solicitor General, keeping in mind the other serious cases where sedition can be one of the offences, along with other serious offences, had pointed out that in other such cases where other offences are also involved, should be allowed to proceed. In fact, should be allowed to proceed, and this request of Solicitor General has also been accepted. So if anything, it's being linked to what the government has done.
See, ultimately, the fact remains that there are laws on the statute book which are much, much harsher than the sedition law also, right?
Okay.
Eventually, it boils down to the fact whether a law is being used or it is being abused. And in the case of Section 124 of the Indian Penal Code, the reason why there are so many petitions before the Supreme Court and the Supreme Court is seized of the matter is because there is obviously misuse and abuse of the law. And therefore, under those circumstances, first of all, the government took a position that they are going to stand behind the sedition law. And then they reversed their position. And when they reversed their position, the court did not allow them or give them a carte blanche. The court has said that please come up with your position by the 17th of May, which is the next date of hearing. Okay. If the court is satisfied with whatever position the government evolves, the court may allow the legislative process to then play itself out and keep the petition in abeyance. If the court is not satisfied, it just might go ahead and adjudicate on the petitions and give its judgment. And what that judgment would be would depend upon the wisdom of the judges.
But Mr. Tiwari, the government has scrapped 1,500 laws since the Modi government came to power in 2014. Would you then not say that the need of the hour is also to simply strike it down? Or are you of the opinion then that if there are necessary safeguards, then the law can continue to stay in the statutory books?
No, what 1,500 laws are we talking about? You strike down or you repeal inconsequential, innocuous laws which have completely and absolutely outlived their existence, laws which may have been made with regard to cane growers in Bihar in the 19th century, or with regard to certain specific issue in Punjab or some other part of the country. So obviously those laws have kind of run their course. So therefore, if you've repealed them, you've not done this country any great favor. You've just kind of cleaned out your own stables. But sedition is something which falls into a different basket altogether. It falls into a different bucket. The reason why you are having this discussion on sedition today is primarily because there are petitions pending before the Supreme Court which are challenging its misuse and saying that it needs to be read down.
Okay. Last question to you. In the 1962 Kedarnath case, the apex court had made it clear that dissent is not sedition. Yet governments, your government as well in the past, it was the Congress which ruled maximum in these 75 years, had slapped sedition cases and nothing was really done to scrap it. During the current government and in the multiple governments in the past as well. Now, tell me what really explains this. Is this not a blow to free speech that is so fundamental as a right for every citizen of this country?
The fact is that these petitions were filed before 2014. These petitions have been filed after 2014. So therefore, that itself is a very eloquent testimony to who was misusing and abusing the law and who wasn't. But be that as it may, in Kedarnath's case also, the court was very clear that there has to be a nexus between words articulated and violence which has erupted. So therefore, under those circumstances, the manner in which the sedition law has been applied is what is causing concern. And so therefore, I think there is enough on the statute books. You have the UAPA and large sections of quota when it was repealed were extrapolated to the UAPA in order to strengthen it. So to deal with sedition or anti-national activity, you have enough laws on the statute book already.
All right, Manish Tiwari, I appreciate your time. Thank you so much for joining us. And today was a day of another verdict or development in the court. In fact, the fight to criminalize marital rape has received another big jolt. I'll give you details after a very short break. Stay tuned.